Good day to everyone. This is a further clarification on the discussion on age of sexual consent. I have read the comments and reactions to the video I previously posted entitled "The age of majority is 18, but the age of sexual consent is 16." And it appears that many are still confused as to what really is the age of sexual consent. Is it 18 or is it 16? This is not to debunk another person's opinion on the matter. My only aim here is to educate my students, first and foremost, and the public in general who are interested to know the law. At the end of the day, we should respect each other's opinions no matter how much we disagree with them. I am going to share here the ruling of the Supreme Court in the case of Bangayan versus People, decided on September 16, 2020, which extensively discussed the difference between the concept of consent under contract law and sexual consent in criminal law. At the time this case was decided, there was yet no RA 11648. Be that as it may, however, the discussion is still relevant because the amendment made by RA 11648 merely increased the age of sexual consent from 12 to 16. Here's what the Supreme Court said in that case. Accordingly, the court deems it prudent to rectify the difference between the concept of consent under contract law and sexual consent in criminal law, which determines the guilt of an individual engaging in a sexual relationship with one who is between 12 years old, now 16, or below 18 years of age. These are concepts that are distinct from each other and have differing legal implications. While in general, under the civil law concept of consent in relation to capacity to act, all individuals under 18 years of age have no capacity to act, the same concept cannot be applied to consent within the context of sexual predation. To apply consent as a concept in civil law to criminal cases is to digress from the essence of sexual consent as contemplated by the Revised Penal Code and RA 7610. Capacity to act under civil law cannot be equated to capacity to give sexual consent for individuals between 12 years old, now 16, and below 18 years of age. Sexual consent does not involve any obligation within the context of civil law, and instead refers to a private act or sexual activity that may be covered by the Revised Penal Code and RA 7610. The Supreme Court further said, there is a need to distinguish the difference between a child under 12 years of age, now under 16, and one who is between 12 years old, now 16, and below 18 years of age, due to the incongruent mental capacities and emotional maturity of each age group. It is settled that a victim under 12 years old, now under 16, does not and cannot have a will of her own on account of her tender years. Thus, a child's consent in such a case is immaterial because of her presumed incapacity to discern good from evil. As such, regardless of the willingness of a victim under 12 years old, now under 16, to engage in any sexual activity, the Revised Penal Code punishes statutory rape and statutory acts of lasciviousness. On the other hand, considering teenage psychology and predisposition in this day and age, we cannot completely rule out the capacity of a child between 12 years old, now 16, and below 18 years of age to give sexual consent. Considering, this is my take, that we cannot apply consent as a concept in civil law to criminal cases, it is therefore wrong to say that the general rule is 18 and the exception is 16. To repeat, the age of sexual consent is 16, not 18. The only time that a minor, 16 years of age or over, but under 18, cannot validly give consent to sexual intercourse or lascivious conduct, as the case may be, is when the circumstances of the case fall under child prostitution and other sexual abuse, qualified seduction, or simple seduction.